If an employer receives a suspect document notice or a notice of discrepancies, basically they have to call the employees in, advise them that there's an issue, that ICE sent a notice, and re-verify documentation. And they want to look and see the documentation, did they transcribe something wrong? If not, the employee's then required to represent document to ascertain their identity and work authorization. If they can't do it, the employers actually aren't told, it's not in the law. ICE can't say you must terminate this employee. That's not their authority. But what they do say in the notice is, unless you can re-verify correct data or they present new data, further employment of that individual can result in a charge of continuing to employ or an additional fine. By and large, the fine data that I've reviewed through FOIAs with ICE and some clients that we've spoken to, by and large, the vast majority of fines out there are for paperwork violations. I've seen very few related to hiring and continuing to hire, knowingly hire violations lately. Some of the fines are for smaller things. There are some, if you don't prepare, you fail to prepare and present an I-9 form, you can pretty much expect to get a fine on that. But there are a number of fines out there that relate to lower level substantive violations or a mix of technical that haven't been corrected and substantive violations. But by and large, the fines that are being issued are generally based almost entirely on paperwork violations these days. The way the fines are structured now are basically, if you have more than 50% substantive violations, you're automatically going to the higher range. The range is 110 to 1100 for a first offense. But the way they structure the fines now is if you have a large number or a large percentage of your workforce, you're going to be on the higher end. So you're looking somewhere between the $600 and $800 range if you have more than half of your I-9s are found to be deficient. There's always negotiating, and then they also have a right to a hearing before a chief administrative hearing officer where fines can be mitigated down. Lately, in the past probably 10 years, the fines have been on the higher end, and the negotiation has not been as strong. When I was doing a lot of the fine work in the mid-90s, it was almost automatic that it was 50% of the intended fine. There have been some policies put in place that keep the fines on the higher end and don't allow for that quick cut it in half and pay up front. As far as collection, I haven't really reviewed any data lately. Years ago, I know there was a high default rate on it. Companies, it would just be cheaper to dissolve the company, reincorporate a week later, and get rid of the $30,000 or $40,000 fine. But lately, I haven't seen what the collection numbers are related to the fines that have been issued. And there are some cases that actually move into criminal prosecution. In my experience, the vast majority of the criminal prosecution worksite cases have a much larger conspiracy involved and involve much more significant charges. Under the worksite, what we would have considered worksite laws, the criminal violations are pattern and practice of knowingly hiring illegal workers, which is a misdemeanor, or knowingly hiring 10 or more illegal workers in a 12-month period. However, your larger scale criminal cases tend to also involve human smuggling, human trafficking, harboring or shielding unauthorized workers, unauthorized aliens. Those are the ones where you start getting into your forfeiture cases. Those are the ones that are usually more accepted by U.S. attorneys' offices, where it's not just illegal employment, it's illegal employment plus these other felonies that are on the books, especially when you have an employer that's conspiring with the human smuggler to actually bring workers into the country directly to the place of employment. That's where you start getting into your significant criminal cases. The advantage of the audits is you can touch many more employers. So you can actually go out and inspect and assess the compliance level of many more employers. The audits are much lower in cost. Many of the auditors don't even go out. They contact the employer, maybe they serve the notice, but a lot of the exchanges are via FedEx, via electronic I-9 copies, mailing or emailing a DVD or a disc back and forth with the records. As opposed to going out and actually looking at the I-9s on site. The auditors don't have to leave the office all that often. So it's definitely more cost effective. The fines are larger in number. However, fines go into the general fund. It doesn't benefit the agency as much. One of the things that we saw is forfeitures. Forfeitures go back into a forfeiture fund within Treasury, with DHS's forfeiture fund was in Department of Treasury, which could offset the cost of our operational expenses to some extent. Fines don't. So that's a negative of fines. The other negative part of doing a primarily audit-only function is that the illegal workers have no fear of being apprehended. Their documents aren't collected. They're just back out there. If a suspect document notice is issued, they can just move down the street and get another job. So that's kind of the large negative with the audit-only process.